The record reflects we are back in session. Parties and counsel are present. All members of our jury or alternates are present. Our witness is back on the witness stand. And Mr. Lyons, you may resume your examination.
Thank you. Mr. Larock, good morning.
Good morning.
How are you today?
Doing well, thanks.
You are a member of the International Society of Forensic Computer Examiners, correct?
I'm certified by that organization.
That was my next question. You're a certified examiner under them as well, correct?
Not as well. They're a separate organization. They certified me.
And as a certified computer examiner with that organization, you are ethically obligated to further the acquisition of analysis of electronic evidence, correct?
Correct.
And you're ethically obligated to maintain the utmost objectivity, correct?
Correct.
And you're ethically obligated to avoid any action that would knowingly present a conflict of interest.
Correct.
So have you been interviewed by the defense documentary team?
Yes, well, yes, I have been.
How many times?
Objection is relevant, Charlie.
Overruled.
I've been asked questions by the defense documentary team on probably about 5 or 6 occasions, I guess.
And when did those occur?
Objection relevant, Charlie.
Sustained, Mr. Lyons.
Did you receive any compensation for those sessions?
No, I did not.
Do you anticipate receiving any compensation in the future for those sessions?
No, I don't.
You're also ethically obligated to thoroughly examine all the evidence, correct?
Yes.
And we talked a little bit about maintaining that objectivity yesterday, but I want to explore that in a little different way this morning. You would agree that an increased familiarity with a case or people or parties involved can lessen that objectivity, correct?
Objection argumentative.
Overruled.
I'm not sure that I do agree with you on that.
So, referring to people by their first name is a certain level of familiarity. You would agree with that?
Yes, I'd agree.
You're not familiar with me, so it wouldn't necessarily be right to call me Britt, would it?
Depending on the circumstances, perhaps not.
Well, until really we met in this setting, you've never known me and never met me, have you?
That's right.
So, even going further and calling someone by their nickname is a deeper level of familiarity. Wouldn't you agree?
Your Honor, this whole line of questioning is irrelevant.
The objection sustained on relevancy grounds and evidence code 352.
Is there a reason that you choose to refer to the defendant by his nickname rather than his given name or proper name?
Yes, throughout the entirety of the case, in almost all circumstances that I've seen, the defendant's name, he is almost universally referred to as Chase in the evidence.
And can you point me to all of those examples then? Have you looked at the complaint?
Objection is to relevance.
Sustained.
So being that familiar with someone and referring to them by their nickname, that's not very objective, is it?
Objection argumentative.
Overruled.
Actually, I believe that that is objective in this case.
You would agree that a person that is most responsible for what evidence is left behind in a crime is the perpetrator, correct?
Objection argumentative and foundation.
Sustained also calls for speculation and conclusion.
Well, you would agree that the last person that touched or manipulated or concealed or destroyed a piece of evidence is the most responsible, correct?
Same objection.
Sustained, same grounds.
You talked yesterday about push-down activity on February 8th on the E-Machine's web browser, correct?
Yes, I did.
For all intents and purposes, as far as you know, that's the last person to use that computer.
Yes, I agree.
And therefore, the logical inference or conclusion from that is it is someone who was involved with a crime.
Objection, same objection.
Sustained, calls for speculation and conclusion.
And that activity is something that someone would be attempting to hide, correct?
Objection, calls for speculation.
Sustained.
You would agree in a computer science field that the frequent user of a particular device would be the one most familiar with it, correct?
Generally speaking, yes.
So, for example, if you're the frequent user of a laptop or a desktop, you're familiar with what's in the favorites, stored favorites bar on the web browser, correct?
Probably, yes.
You would be familiar with what prior searches that were conducted using Google Toolbar.
They would be familiar to you, yes.
Someone who was not familiar with those things, you would agree, would have to go searching for them, correct?
A person who is not familiar with them could go searching for them, yes.
You would also agree, isn't it true, that an IP address is actually provided by an ISP provider, not the device?
Correct. It's provided by the ISP.
So the device does not determine what the IP address is, correct?
The device knows what its IP address is, but it is the ISP that assigns the IP address.
Again, my question was, the device does not determine what the IP address is, correct?
If I understand you correctly in asking if the device comes up with the IP address on its own, the case is usually no.
Again, my question was, let me backtrack to make sure you're understanding and clear. It is the ISP, the Internet Service Provider, that supplies the device with the IP address when service is connected.
Generally speaking, yes.
So it is not the device that determines what IP address is used, correct?
In most cases, it is not the device that assigns the IP address, it is the provider.
And isn't it true when someone connects to an Internet Service Provider to conduct some type of activity on the Internet, it is possible that multiple Internet Service Providers can be used in that course of conduct, creating a chain, correct?
I'd like some clarification. Are you speaking of one session of using the computer, or are you speaking of using a computer over a period of time, days, weeks, months?
Well, let's start with one session.
So are you asking if in one session the device could be assigned multiple IP addresses?
No, I did not say that. What I asked, sir, isn't it true that multiple ISPs or Internet Service Providers can be used in a single session to create a chain of connectivity?
Generally speaking, when you are connected to the internet via any device, you're using one internet service provider.
Again, I didn't ask generally speaking, sir. I asked, isn't it possible that in a general session, multiple ISPs can be used to create a chain of connectivity for a session?
Objective, the question seems to be vague.
The objection sustained, the last objection is sustained as phrase.
Again, would it help if I had the court reporter read back the question I asked you originally?
I don't think so. I'm not completely clear what your question is. I think I understand, and I think I can answer if you'd like me to try.
Sure, give it a shot.
Okay. So I believe you're asking if during a single internet browsing session or internet activity session, if you can be, if your device can be connected to multiple internet service providers at the same time. I see you're shaking your head, which seems to indicate that I'm not answering your question.
That would be correct, sir. The question was very simple. Isn't it true?
We object to the commentary because it doesn't seem that simple.
Sustained.
Isn't it true that during a single session, it is possible that multiple ISPs will be utilized, creating the chain of connectivity to whatever business is being conducted?
Utilized?
Utilized to create a chain of connectivity to whatever activity is being used.
I don't understand the chain of connectivity that you're referring to.
Isn't it possible that if I connect to my ISP, I'm going to get an IP address, correct?
That's correct.
And I'm going to do a specific task on the internet, correct? Whatever it is.
Presumably, yes.
Isn't it possible in that connectivity to do that business that that ISP will be required to or need to connect to another ISP in order to carry out its task?
Oh, I think I see what you're saying. So you are saying rather than the device being connected to multiple internet service providers, that the device would be connected to an internet service provider, which would then connect out to another provider to connect to the internet along those lines.
So would that be a yes?
Yes, that's possible. Yes.
That would be that chain of connectivity.
Okay, I understand what you're saying.
So that would be a yes.
Well, I'm not familiar with the term of chain of connectivity, so but I understand what you're saying.
You're familiar with a VPN, which is a virtual private network, correct?
Yes, I am.
And a virtual private network will reflect an IP address for the location of the network, not the device using the network, correct?
Generally speaking, that's true. A virtual private network can be a bit more complicated than that, but generally, yes.
And a virtual private network is commonly used by individuals to mask their IP address and location, correct?
It frequently is, yes.
It's used by businesses, governments, individuals that are free available online today, correct?
Correct.
Sorry, that was very compound. All of those things are correct.
All of those things are correct.
Thank you. And you're familiar as well with a virtual desktop environment, or a VDI, correct?
I'm not familiar with the term VDI, but I'm definitely familiar with a virtual desktop?
Yes.
Okay, then actually I thought you were referring to something else. Could you explain, please?
You're not familiar with a virtual desktop environment?
I'm actually not sure what you're referring to by virtual desktop. There are many things that sound similar to that.
Isn't a virtual desktop environment one in which there is a centralized network that a device accesses?
I'm not familiar with the term virtual desktop environment. If that is a term that you're referring to here, then that could be very well the case. I'm not familiar with it.
You're not familiar with the network capability of, let's say, using our laptops here in court to connect with our central network across the street. That type of network connectivity.
Yes, I'm familiar with that type of connectivity.
And that virtual version would be as if I was sitting in my office across the street, utilizing all the same tools, printers, and all of the same devices and applications that are available.
Yes, I'm familiar with that. I'm used to that being referred also to a virtual private network.
And in both cases, that VPN or virtual desktop environment would use the IP address of the centralized network, not the device, correct?
Generally speaking, that's true, yes.
There also exists a plethora of technologies out there to mask an IP address, is that correct?
Yes, that's true.
And there is a plethora of technology that exists to spoof IP addresses, correct?
That's also true.
You would agree that someone, I like beating up on lawyers because I am one. Someone just, a routine lawyer using a laptop, Google searches, is probably not the most versed technologically, in general. Would it be fair to say?
Can you repeat the question? I'm sorry.
Sorry. Some people are not techie nerds, like really skilled at things. They can send emails, they can Google search, visit websites, use Amazon, stuff like that. Real basic knowledge, right?
Sure.
Okay. You would agree that people that engage in conducting online businesses, hosting websites, etc., have more advanced knowledge?
Generally speaking, yes.
Well, what percentage of the population would you guess knows how to build and maintain a website?
It depends on what level of website you mean. Building something from scratch would require a lot of skill. There are also tools that allow you to very quickly, a person without training, to create one.
Well, and that kind of goes to technology in general. Since 2010, technology has changed and grown rapidly in just the 9 years, right?
Very much so.
So in 2010, for someone to build a website, maintain a website, and operate a business through a website would have been a lot more complicated and taken a lot more skill than necessarily it would now in 2019.
Yes, I agree.
So, for example, some of those commercially available free tools to create your own website didn't exist in 2010.
That's right.
Yeah. What are some of those?
Wix is a common one.
Wix. Okay.
There's a Squarespace, I think, or something like that. Yeah.
Okay. So those things would not have been available in 2010. So creating a website and running a business through it would have taken a lot more skilled person. Would you agree with that?
In 2010, yes.
And a person like that would have the skill and knowledge potentially to know what a virtual private network is and how to utilize it.
Objective speculation.
Overruled, you can answer if you have some opinion.
I'd agree that somebody with that technical skill often would be familiar with VPNs, yes.
And it's just as likely that such a hypothetical person would know how to mask an IP address or spoof an IP address.
Objection calls for speculation.
Yeah, you can offer an opinion if you have one.
That one I can't necessarily agree with. It is a different realm. We're talking more about computer security at that point. I couldn't say that somebody who knows how to build a website would know how to spoof their IP address.
Well, being in the business of being able to manipulate Google results, that's even a higher skill level. Wouldn't you agree?
Actually, I'd say it's a different skill level.
So it's unique.
Well,
Not
that's,
everyone would have it.
Could I explain just a bit my answer?
Sure.
You're referring to search engine optimization, which is an entirely different skill. That's actually more of a marketing skill. I would actually take that a little bit. It definitely crosses into the realm of technical, but it's a different skill.
So in this case, you wrote a report that you turned over late Sunday night into early Monday morning, correct?
I'm sorry, can you repeat the question?
So in this case, you wrote a report that you worked on drafting for since 2000, what you said, 18, right?
I started the report in 2018, yes.
Okay, but you didn't turn it over until late Sunday night, early Monday morning, correct?
That's actually not completely accurate. My understanding is that counsel provided it at that time.
When did you provide it to counsel?
I mean, I did provide it to counsel shortly before then. I just finished it.
And the purpose of that report was to document your findings of your examination of electronic devices in this case, correct?
It was to provide a summary of my findings.
And in drafting that report, it was your intent to be as complete and accurate as possible.
Your Honor, objection. Now he's testifying. Is there a question?
Overruled.
Can you please repeat the question?
And in drafting that report, isn't it true, you wanted to be as complete and accurate as possible?
I wanted to be as accurate as possible. The report was not intended to be a complete description of all of my work.
Well, and also your purpose is to comply with your ethics, is to do so objectively, correct?
Yes.
And when you do so objectively, you don't make assumptions about things, do you?
I'm not sure that I follow. I mean, when I'm being objective in looking at the evidence of a case, I'm providing the evidence of a case. I'm not.
So you wouldn't make
providing-
assumptions then?
I'm sorry?
So you wouldn't make assumptions then?
I'll have opinions which are very different from assumptions.
So you wouldn't make assumptions then?
Your Honor asked and answered.
Actually, Your Honor, you did not.
Overruled.
I think it's very important to differentiate an assumption and opinion. As I understand you're referring to
Objection,
an assumption.
non-responsive, move to strike.
Overruled, you can explain his answer.
As a forensic expert, a large part of my job is to form opinions based on the evidence that I see, to come up with conclusions based on the evidence, and to analyze and interpret what the evidence says. That is an opinion. I don't want that to be confused with an assumption, which I'm not exactly sure what you mean, but I think that what you mean is to believe that there are facts where I don't have evidence of those facts.
Well, my question was really simple, and I didn't ask about opinions.
Your Honor,
You're
again,
not-
he's commentary. We'd object to any commentary and just ask questions.
Objection sustained.
You were simply asked, you were not to make assumptions, because that wouldn't be objective, correct?
As I have defined the difference between assumptions and opinions, I would agree with what you said.
And being objective means not drawing any conclusions from the particular evidence, correct?
No, I disagree with that statement.
Okay, we're going to revisit that one shortly.
Your Honor,
And objectivity draws no emphasis to the evidence, does it?
Can you repeat that, please?
Being objective draws no emphasis to the evidence.
I'm not entirely sure I understand. I definitely need to emphasize parts of evidence that support findings.
And you find that to be objective to emphasize one piece of evidence over another.
Your Honor, again, these questions are argumentative.
Overruled.
Can you please tell me what you mean by emphasize?
To make one more important than another?
I look at, when I'm examining a case, I look at evidence treating the pieces equally. However, I understand that in any case there is bound to be a tremendous amount of evidence, so I do have to make good use of my time to locate evidence that is applicable to the case.
So I'll take, is that a no?
I don't recall the original question at this point.
Well, the question I did ask, sir, was being objective does not place emphasis on one piece of evidence over another, does it?
I mean, I believe that depends on how you are defining it. If you have two pieces of evidence that both pertain equally to a question in a case, then being objective means that you're going to place the same emphasis on them. If you've got two pieces of evidence, one of which is directly applicable to the question at hand, and another piece of evidence that has nothing to do with the question at hand, then I would say it definitely makes sense to place more emphasis on the evidence that pertains.
You would agree that the use of subjective terminology would not be objective.
Could you please verify?
The use of subjective terminology, or words or phrases, would not be objective in an analysis, correct?
I'm really not quite sure what you mean. Could you give me an example, possibly?
How many times in your report did you use the phrase notably?
Notably, I'm not sure how many times I used it.
Would it surprise you that you did?
No, it would not.
And in fact, isn't it true you use the phrase potentially very important?
That probably is something that I wrote.
And especially significant, you wrote.
Yes, that sounds right.
In a good business relationship.
I believe I wrote that.
In a significant source of income.
That also sounds like what I wrote.
So using the words like significant and especially and notably, those are subjective terms, aren't they?
suppose it could be defined that way. I think that in the context of my reports, it was entirely proper to use those.
So when you said a good business relationship, what assumptions were you making to come to that conclusion?
Objection assumes facts not in evidence and assumptions are made.
Could you repeat one more time, please?
When you described Joe and the defendant's business relationship as good, what assumptions did you make to come to that conclusion?
What I was doing at that point was I was referring to the records that I saw on the computer documenting the finances, the activity, the jobs between Joseph and Chase Merritt, and looking at the dollar amounts at that point. I was considering that in the context of what people make in a living. And that was what I was using to base the good business relationship on.
Well, and to be thorough and complete, you compared, to come to that conclusion, you did compare it to other evidence in the case, didn't you?
The findings of the business transactions, the finances, is that what you mean?
Well, your conclusion of a good business relationship. In order to come to that conclusion that it was good, you considered the totality of the evidence in this case, didn't you?
Yes, I did. I also compared it with emails, with documents, with invoices that I saw on the computer. I compared it with quite a lot of evidence that I found, yes.
Did you consider the testimony of multiple witnesses that knew that Joseph was attempting to sideline the defendant from the business?
Your Honor, objection, the testimony of that was stricken as lack of foundation, so this is evidence that is not before the jury, has not been properly admitted.
Overruled.
Can you repeat the evidence, or the question, please?
Were you made aware of, or did you consider or look for the testimony of several witnesses who talked about Joe trying to sideline or replace the defendant in this business?
Trying to, I'm actually not sure what you mean by sideline. By replace, you mean terminate and use somebody else for that? That's what you're referring to?
I'm using the common definition of the word replace, sir.
Your Honor, we'd ask the counsel not argue with the witness.
Sustained is argumentative.
Your Honor, he asked me a
The
question.
objection sustained is argumentative.
So did you consider the testimony of David Cicada about having to clean up and repair and fix and finish projects for the defendant when he was multiply absent from his job?
No, I'm not familiar with that testimony.
So the basis for the good business relationship was not a thorough and complete analysis of all the evidence.
Objection, argumentative.
Sustained.
You indicated in referring to, let me see if I can find it in your list of exhibits, and maybe you can assist, the payoff email. What exhibit was that? Was that 10?
I'm sorry, I can't hear you. The what?
Sorry, the payoff email. Do you recall what exhibit that was, sir?
I think that we're looking at, I had several exhibits in there about the exchanges between Dan Kavanaugh and Joseph.
Would looking at your trial script help?
I've got it in front of me,
Oh.
thank you. But I think that you're referring to 2C in my list.
And you indicated the significance of that, and for the record, that's actually exhibit 1025. That this was sent from Joseph McStay's email address to his own other email address. Is that correct?
That's what it appeared to be, yes.
Well, the to email address is eipfountains@yahoo.com, correct?
Let me see. Yes, that's right.
Okay. Do you have your own set of exhibits up there, or?
I don't. I have my copy of the exhibits.
That's fine, it'll save me from walking back and forth. Okay, so did you contact Yahoo to determine who the owner of that account was?
No, I did not.
Did you contact Yahoo to determine who had access to that account?
Actually, if I can make a slight correction to what I just said, I did request and assist in providing language for a subpoena that was served upon Yahoo for information for that account, which includes the account ownership, information relating to the accesses of that account, as well as many other of Joseph McStay's accounts and some of McStay's accounts, as well as the contents of that account itself. My understanding is that that request was denied, that we were not allowed to get that information.
Nonetheless, you have no knowledge, no forensic evidence that other people may have had access to that email address.
I'm not familiar if other people did have access to that email account.
And you were at least made aware, isn't it true, that EIP Fountains involved at least 3 individuals in that business, correct?
Yes, I believe that's correct. The hesitation right now is that the fountain business certainly involved at least Joseph McStay, Chase Merritt, and Dan Kavanaugh. However, there's 2 facets of this business. There's I'm not sure if the names of each one. There's the custom fountains, which Chase was building, and then I believe there's sort of more generic fountains that were created. And I'm not sure who is involved in the 2 facets for that.
And you're not sure which email address this part of the business belongs to, do you?
I'm not positive, no.
So when you said that it was common for someone like Joseph McStay to send it to themselves to safely store it on the internet, you were making an assumption.
I was providing context to this because I thought it was important to give a reason why somebody would email something to themselves.
To the exclusion of all other possibilities?
I don't believe I did exclude all other possibilities.
So it's possible. In your testimony, you did not mention, did you not? Tell us, correct me if I'm wrong, that he could have been sending that to Dan or the defendant who had access to the email.
Objection. Assumes facts not in evidence. Anybody else had access?
Sustained.
That's my point. You assume that only Joseph had access to that email. Is that correct?
I wouldn't call it an assumption. I have the evidence that I saw showed Joseph regularly using that account, and I was providing context as to the most likely scenario from my professional experience as to why people email themselves documents. It's something that I see very commonly.
In your analysis of the computer, this email you say was opened in Google Drive, but you did indicate that you did not have access to the Google Drive account. Is that correct?
I think you referred to opening an email in Google Drive. That doesn't sound right. I'm not. Can you please clarify?
You're the one that testified to it. You testified or wrote in your report that this document or email or whatever it is was opened in Google Drive.
Your Honor, object. Now this is testimony.
Isn't that what you testified to, sir?
I think you're referring to the 2009 finances spreadsheet. So that's a spreadsheet document, not an email, that was opened from Google Drive.
Did you not write in a report that you did not have access to Joseph's Google Drive account?
I may have written that. In general, I did not have access to his Google Drive account. This particular document was publicly facing. You didn't need to have access to the account to be able to access this one.
You also wrote in your report that payments continued to be on his, Joseph's, mind through at least much of 2009.
Can you repeat that? I'm not sure what that is right now.
In regards to finding this email about the payoff, you wrote, payment to Dan Cavanaugh continued to be on his mind through at least much of 2009. Isn't that what you wrote?
Yeah, that does sound like what I wrote.
Can you read Joseph's mind?
I'm able to look at evidence that shows what Joseph's activity was. And there, in this particular case, there was activity related to these payoffs throughout 2009.
However, you don't know the mental state or the emotion or the intentions behind any of it, do you?
I don't know what the context of what Joseph was doing at the time was, but I know that the documents, this email, the payoff, certainly were crossing his mind throughout 2009.
So you are subjectively inferring Joseph's state of mind rather than just relying on the facts.
Yeah, objection, argumentative.
Sustained.
You would agree that speculating as to someone's state of mind would not be very objective.
Objection, argumentative.
Sustained.
You wrote in your report you were, quote, directed to analyze the devices collected by law enforcement, correct?
That's correct.
Who gave you that directive?
Originally my partner, Sherry Katz.
You provided and relied upon several exhibits which were the QuickBook activity logs. You remember those?
Yes, I do.
Okay, and those were already actually marked as exhibits 421 and 423. Here's 423, the custom side. And here's 421, the contact side. Those look like to be the same?
Can I see this?
Yeah.
I mean, these are not quite the same as my exhibits. It looks like they're all from the same document, but it's a limited number of different pages from the same
Sure.
document.
Can I have those? I don't want to lose those. Miss Amador gets mad at me when I lose exhibits. So, what device did you retrieve those documents from?
Those were contained within the discovery documents that we received.
That was not my question, sir. My question was, which device did you forensically obtain those documents from?
Those documents were part of discovery. They were not contained within in the evidence.
You relied on Mr. McStay's phone records, correct?
Yes, I did.
And which device did you forensically obtain those records from?
Those were also provided by discovery as opposed to being contained within the evidence. It wouldn't make sense to find those types of records within the evidence.
Those were not pieces of evidence that were stored on electronic devices that you forensically examined, were they?
In terms of the forensic images that I was asked to examine, they were not part of that. No, they were provided in terms of the context of the case.
So you exceeded the scope of actually forensically examining devices.
I exceeded the scope. Well, no, I wouldn't say that I exceeded the scope. I looked at the contextual documents that were provided to me in addition to the evidence.
Just to clarify something, the text message that you referred to yesterday, which I believe was your Exhibit 3H, which is Exhibit 1034. Do you recall that?
Yes, I do.
You left, or you testified, isn't it true, that was found on a device that you described as Joseph's phone, correct?
Correct, a phone that Joseph used.
Yeah. Do you know when that phone was in use?
In this particular case, this was the beginning of January.
Were you made aware of other evidence that showed that that was an old phone no longer in use?
Objection, argumentative.
Well, we will look at this if he was aware of that.
I did see from the evidence itself that the time usage of this phone was very limited. There was not much data on this phone. It appeared to be a phone that I would not describe, did not seem as though it was Joseph McStay's main phone.
Were you made aware, was the question, of evidence that it was not the phone Joseph was currently using? At the time of his disappearance?
I don't recall anyone specifically telling me that.
Did you attempt to make yourself aware through evidence from the witnesses who have testified to that exact fact?
I did not look specifically for testimony for that. I believe the evidence spoke for itself in this case. The time was very limited on this phone.
But you didn't mention that in your direct testimony, did you?
I was not asked that.
Wouldn't you agree that by not testifying that and not clarifying that left the implication that that text message was found on his currently used phone?
Objection, Your Honor. This is again argumentative.
Argumentative, and the objection sustained is argumentative and calls for stipulation and conclusion.
Don't you believe it would be important to know that the evidence deduced at trial indicated that Joseph's current phone was not able to be located?
Vague as to time.
Objection sustained on the same grounds.
Were you made aware of, as part of your analysis, to be thorough, that Joseph's currently used phone at the time of his disappearance was never located?
I believe I was informed that, and again, looking at the evidence itself, it seemed very clear that that was most likely not Joseph McStay's primary phone. It was so limited in time.
So let's turn to these spreadsheets you found for 2007, 2008, and 2009. You recall testifying about those yesterday?
Yes, I do.
Did you actually test the equations in the Excel spreadsheets to verify that they were running accurately?
Yes, I did.
Excuse me while I try to pull this up for you. So I'm going to pull up exhibit number, it's your number 3C. Which would be court exhibit $10.28. You have a copy of that, sir?
I'm looking at my 3C.
Is that what's being displayed currently?
Yes, that looks right.
And you would agree that these columns total to the right? correct? From left to right?
Meaning that the balance is the total of what's to the left?
Yes. The equations work adding from left to right to the last column balance, correct?
Adding, subtracting, however you want to say it, but yes, they were, it was doing addition or subtraction on the chase dollars versus the payments.
Okay. And those columns also accumulate and total at the bottom, so they total vertically, correct? Within each column.
I believe that was the case. Looking at it now, I see that very clearly the bottom right cannot possibly be the grand total of that sum. I checked quite a number of cells in the spreadsheet. That particular zero may not have been an automatic calculation, though.
So your testimony yesterday regarding that and just now was a little less than accurate, correct?
Clearly I was mistaken that the grand total was absolutely an Excel automated calculation. Most of the cells in here I definitely recall were automatically calculated. Clearly the zero in this case can't be the total because there's just looking at the sum of the balances, there's a minus 200 there.
The rest of the column is zero, but except for that one minus 200, correct?
That's right.
So that bottom line should say minus 200, right?
If it were automatically calculated for that column, then yes, that would read minus 200.
So let's turn to the 2008 one, which I believe is your Exhibit 3D, Court Exhibit 1029. Is that what's being displayed?
Yes, it is.
Mr. Jackson, can we have the lights so that the front screen is still real washed out? Thank you, sir. And again, you attempted to verify that the equations in the spreadsheet were working accurately, correct?
I did, yes.
Would it surprise you to learn that the ending balance down here in the far left-hand column is again $200 off? Or sorry, right-hand column is again $200 off.
I did not know that. Again, I compared most of them. I could be misremembering about the final total balance.
Would you like a calculator, or are you willing to take my word for it?
I'm willing to take your word for it.
Okay. But more importantly, I wanted to look at a couple of things on this exhibit. So the bottom half of the exhibit appears to be, would you describe it as a kind of a notes section regarding transactions and payments?
From the context that I've seen throughout all of the spreadsheets, that's what it appears to be.
Okay. But we have to somewhat be subjective about that because we really don't know, right?
Well, we have to compare the different pieces of evidence to form the best opinion as to what they are.
So when we scroll down to the bottom, there was this notation of overpaid through 12/2/08, $9,461.85 plus, it says plus, Provecho disaster, $34,000. See that?
I do.
And 2 lines above that is $2,000 to Brian Central, paid for feature, never got it, exclamation point 3 times.
I see that.
Did you run or do any calculations to verify the accuracy of this data that you were recovering from the computer?
I'm actually not sure I understand the question.
Well, you indicated that you checked the cells on the spreadsheets and you thought they were accurate, and it turns out they're not. Did you run any of the math in these notes at the bottom of the page to determine their accuracy?
For the most part, these the numbers in the bottom part of this don't give me a whole lot of context. There was I know there was certainly one example in the 2009 spreadsheet of payments made from Joseph to Metro Sheet Metal and Chase Merritt that I did compare with QuickBooks Online records. Most of the transactions in here, I don't have a whole lot of context to, but no, I did not compare those.
So let's move on to the 2009, the first 2009 you found, which was Exhibit 3E, Court Exhibit 1030. Do you have that?
I do.
And is that what's being displayed now?
Yes.
Okay. And this is found where?
This was on the e-machine under a folder fountain/EIP/Chase/accounting.
Okay. And it only has, what, 3 lines in it and 2 notes on the right-hand side?
For the first part, yes.
Yeah. And then it appears the notes continue or repeat from the previous 2008 one, correct?
That sounds familiar. Let me take a look.
Well, you see here the same 2 notes about Brian never got it and overpaid
Your Honor, he asked,
$9,000 plus $34,000.
Your Honor, I object. He asked him a question. He says, let me check my notes so he can give an answer. I'd ask you to be allowed to answer the first question.
We'll clarify the question.
I didn't
As a
hear
point
the
of
clarification.
clarification, you see the same notes that we just saw in the previous spreadsheet from 2008, correct?
Yes, I see repetition.
But again, then this changed where there was this at the bottom, this box on the right-hand side, correct?
Let's see. So the box exists in both, but it's got different information.
It exists in the 2008?
Yes. Well, there's a similar box in 2008.
Well, I put it back up on the screen.
It's at the very bottom.
Oh, there it is. I must have missed that. Thank you for catching that. So
Stipulate counsel made a mistake.
that box has a certain amount of information, correct? In the 2008 one, which is Exhibit 1029.
Yes, it has information there.
It has overpaid $23,562 plus the Provencio disaster $34,000, and then totals out at $64,000, correct?
I see that, yeah.
Okay. So then when we go to 2009, it appears to have that same information except for it's added some more numbers to that, correct?
Let me see. It's very similar. The box from 2008 is mostly the same as the midsection here. Most of that information is the same. The 2008 one does have all of those numbers, although in a different color, and then the total is different.
So now the grand total is $90,750.
That's the total listed, yes.
The overpayment totaled $50,250, correct?
I don't, wait, say it one more time, please?
The overpayments listed at the top totaled $50,250.
That's what it appears, yes.
And then adding to that overpayment subtotal was the $6,500 from the middle box, correct?
Yes.
And that totals $56,750, correct?
Yes, it does.
and then you add the prevention of disaster at 34,000, that gets this 90,000 at the bottom, correct?
Let's see. Yes, that looks right.
So then you found another version of this on the Google Drive, right?
That's right.
Would that be the Google Drive you said you had no access to?
I believe it was stored within Joseph's Google Drive account. He accessed a link to that, which I followed, which showed that it was a publicly shared link.
And that would be item 3G, is that correct? Exhibit 1033 for the court, is that correct?
Yes, I have it as a combination 3F and 3G, but yes.
1030, I'm making sure my notes are right, 1033. And in this, the spreadsheet had changed, correct?
From what we had on the computer, yes, it had been significantly updated.
What was the time difference between the last access date of the first 2009 spreadsheet and now the Google Drive 2009 spreadsheet?
I don't know the last access time of the Google Drive spreadsheet. That information was not presented to me. What I did see and what I testified to was that Joseph had used Firefox to access the document in, I believe, August. The first version showed a last written time, last modified time of February 2009.
So sometime between February and August, if we want to be subjective, we can assume that someone, maybe Joseph, modified this spreadsheet to what it now looks like.
No, I would disagree with that. Can I clarify?
Sure.
Okay. So we know that Joseph accessed the document in August 2009. That doesn't mean that there absolutely could have been accesses before that and then after that. I don't have the time that the document was last modified or last written. So in August, we know he opened up the document, he may have modified it. I would think, given the context, given the information contained in the document, that the final version of it, as we see today, probably is not what it looked like in August, because there's transactions listed throughout 2009 and going into 2010.
My question, sir, was, it is reasonable to subjectively infer that somehow the document was modified between the February access in 2009 and what you found was viewed on August of 2009, and how you found it on the computer.
Subjectively, I don't know that I would, I'm not sure how subjectively fits into that. Objectively, we know that Joseph accessed the file at that time. I don't, from the evidence that I examined and the evidence that we see before us, I don't have a way of knowing what he had modified or what the state of that document was at that time in August.
They don't look the same, do they?
The version of the spreadsheet that exists today definitely looks very different from the version that existed in February of 2009.
So that would be a yes.
They look very different now. The difference between what I'm saying and what you are saying is it seems to me that you're saying that the version of the spreadsheet is how it existed in August 2009, and I don't believe that that's correct.
One of the changes, sir, was the addition to this Metro, and it's DIMIC, Metro-Dimic column. Is that correct?
Believe that's right. Let me check the previous version.
I have it displayed if
That's-
that helps.
Oh, thank you. Correct. The previous version didn't have that column.
But it shows no transactions until we get to October 2nd, roughly. Is that correct? In that column to MSM Dimick.
Yes.
Okay. In order to be thorough and compare all the evidence to give it context, did you consult any other evidence to determine a reason or a context why these Metro sheet metal entries don't start until October?
I did not compare those records with, or this information with other records for Metro sheet metal.
Did you look at or obtain Mr. McStay's bank records?
I believe there were bank records within the discovery. I did not I did not spend a great deal of time on the bank records.
Did you look for other canceled checks to Metro sheet metal during any time period in those records?
No, I didn't specifically look for that.
Did you look at the QuickBooks activities, the actual audit histories for checks written to Metro sheet metal to determine a time when they would have begun?
I don't believe I had access to that information throughout the course of this examination.
It wasn't in the discovery you were given?
Check audit logs
The QuickBook audit logs.
for checks, you're asking, please.
Yes.
I specifically remember check audit logs for the checks in February of 2010 made out to Charles Merritt and I believe Metro Sheet Metal.
But you didn't look
for
beyond
my,
that?
No, can you finish his answer?
Let him finish his answer before you ask the next question.
but from I did look quite a bit to see if I could find additional check logs before in addition to that, and as I recall, that was all the check logs that were made available to me.
Did you attend the testimony of Mr. Cicada or read the transcript of his testimony regarding the activities of the business Metro Sheet Metal in relation to Mr. McStay during the relevant time period?
I don't believe I reviewed that testimony, no.
So,
Overruled the answer you made.
did you find that not important to the context of the activities of Mr. McStay around that time?
Objection, argumentative.
Overruled.
Can you repeat the question, please?
Did you not find it relevant to provide context to the activities of Mr. McStay around that time period?
I definitely found the activities of Joseph McStay around this time period to be relevant, and I searched for and presented a great deal of evidence related to that.
But not all of it and not thoroughly. Would that be fair to say?
Objection, argumentative.
Sustained.
Well, you did not go back to look at his history or relationship with Metro Sheet Metal to see if it gave context to these transactions, did you?
I didn't specifically look for the transactions in this spreadsheet related to Metro Sheet Metal.
You said in your testimony and in your report that part of your intent was to provide context and meaning to the daily activity and lives of the McStays around the time of their disappearance and murder, correct?
Yes, that's part of what I was doing.
And that business relationship with Metro Sheet Metal, did it not fit into that narrative?
I'm not as familiar with Joseph's work with Metro Sheet Metal. I certainly saw it in some of the work that was done, and I saw it in some communications. So I certainly think that it had some relevance, but I was not as familiar with it.
And again, the notes at the bottom of Exhibit 1033 seem to replicate those that you were found on 1029 and 1030. Would that be fair to say?
Give me just a moment to compare. Comparing this with which one? If you could just give me the year or version, that would be best.
Well, we're talking about the more freehand notes, not tables at the bottom, and they appear to replicate some of the material that came from 2007 and 2008 and the 2009 Excel version. So that would be exhibits at least 1029, 1030 to now 1033, right?
Let me compare. Just a moment, please. Yes, there's definitely repeated information.
Such as Brian Central paid for, feature never got. We've seen that before, correct?
Yes, we did see that.
So, from a forensic standpoint, it doesn't appear that that changed.
It appears that cell stayed, yes.
Now, this box in the bottom right that we've talked about a couple times, it has changed though from the previous versions. Is that correct?
Sorry, I was just looking at a difference that I did note there, but it looks like it's just a spacing in the Excel spreadsheet. Can you repeat the question?
The box in the lower right-hand corner that we've seen before about overpayments, that has changed now in this Google Drive version of the 2009 spreadsheet. Is that correct?
Yes, it has changed.
And there's more data there, to be fair, to use the word, right?
Correct.
Okay. And so now the overpayment line at the top is 4 entries long, correct?
Yes, with a separator in between. But yes, there's 4 entries there.
And it now totals 169,000.
That looks about right. I'm just trying to make sure that actually is the total of the 4. That looks about right.
Okay. And the middle section has changed a little bit. It's gone down to 3,500, correct? It was previously 6,500, wasn't it?
Yes, that's right.
And without busting out a calculator, the 169 and the 3,500 appear to total 173 that's listed.
Yes.
Then you add in the Provecho disaster, but now we have a new line, Levine disaster. Is that correct?
Yes.
And that is 34,000 plus 8,800, correct?
I'm just making sure that they're all being added together. But that looks about right, yes.
So that totals now 207,000.
Yes.
And then you see the calculation at the bottom of total paid, chase owed, overpaid, right?
Yes, I do.
Was there a reason why you did not explain forensically the existence of this box in the bottom right yesterday during your direct testimony?
This box, when I looked at it originally, well, it still poses some questions to me. I'm not sure how well I understand this box.
Well, but as a forensic examiner, you're supposed to be objective, correct?
Yes.
And the facts speak for themselves, correct?
Yes.
And so the fact that this box has changed from the previous version you saw from 2009 to now this version in 2009, that's the only thing that matters, correct? If you're objective.
That's the only thing that matters? I'm not sure. I think there's a lot of significance in here besides just the fact of the change.
But that significance would be subjective interpretation, would it not?
Objection argumentative.
Overall, you can answer.
Can you repeat, please?
But the significance of that would be a subjective interpretation of the meaning of this. Wouldn't that be true?
Again, I disagree with the terminology. My understanding of what you're referring to is subjective. I think it's important to consider as much of the evidence as possible and to attempt to form an opinion based on it.
And speaking of Metro Sheet Metal payments, you emphasized yesterday several checks written to Metro Sheet Metal on a particular day, I don't know, was it the, whichever day it was. So you were aware of Metro Sheet Metal, right?
I'm aware of Metro Sheet Metal as well as checks written to Chase Merritt and Metro Sheet Metal over the course of January, and it logged in QuickBooks for February of 2010.
But you focused only on those checks created to Charles Merritt and Metro Sheet Metal on that given date, correct?
I don't know that it's fair to say that I focused only on that. I was attempting to give context to evidence that I saw, to compare it with other pieces of evidence to understand better, and to the best of my ability and understanding of spreadsheets where there's not a lot of context, to try to put some meaning to it.
But in order to give context and meaning, you refused or failed to look at other checks or transactions to Metro Sheet Metal that occurred prior to that date.
For the question I was attempting to answer at the time, that was not evidence that seemed the best use of my time to look at.
You prepared the exhibits, didn't you?
All of my exhibits for my testimony, is that what you're referring to?
Yes.
Yes, I did.
But you didn't include any of the checks that were written on previous occasions to Metro Sheet Metal, did you?
I didn't include those. I'm not aware or particularly familiar with the previous checks.
Were you directed to focus on those checks on that particular date in February?
No, I was not.
So, failing to look at the broader context of the Metro Sheet Metal checks and evidence would not be thorough, correct?
Your Honor, objection argumentative.
Can you repeat, please?
Refusing to or failing to consider the full context of the Metro Sheet Metal transactions would not be being thorough in your analysis, correct?
No, I disagree. In especially a case like this where you've got the mountains upon mountains upon mountains of evidence, millions of files, millions of lines to look at within that, I very much so have to make the most efficient use of my time and efficient use of the money that's being paid to my company for this. So it's incredibly important that I look, that I prioritize and I look at the evidence that is going to, I believe, is going to answer the questions at hand. I can't look at everything.
Who poses the questions?
Questions either come from myself or sometimes I did receive questions from defense counsel if I could clarify certain aspects of the case.
And you, for some reason, don't believe the disappearance and death of a family of 4 is important enough to look at the full context?
Objection, argumentative.
Sustained.
You were asked and you confirmed on direct examination that these multiple boxes on the spreadsheet that showed a balance 0 were, quote, fairly even. Is that not what you confirmed yesterday?
My recollection of that and my understanding from looking at those boxes was that it showed a 0 balance between Joseph and Chase at the end of the spreadsheet.
But you were specifically asked by Mr. Moline, that appears they are fairly even, correct? That's what you were asked, and you said yes. Isn't that true?
I don't believe, I'm sorry, I don't recall the exact question, but that sounds about right.
That's a subjective judgment call, isn't it?
I disagree with the term subjective again. I think that we're looking at the evidence presented in the spreadsheet and looking at what appears to be a 0 balance.
Except for you have this box on each of the spreadsheets that shows the defendant being overpaid in the tune of $20,000 at a shot. You would call $20,000 in debt fairly even?
Objection misstates the testimony.
Argumentative, Your Honor.
The
Counsel,
objection sustained, compound and argumentative.
Your Honor, can we approach?
No.
Well then, if the court would please admonish prosecutor, because he doesn't understand the context of these, obviously, through his questions, and the court is allowing that to continue with these
Your Honor, this is highly
argumentative
inappropriate.
questions.
If there's a request to approach,
There was one.
And it was denied, and that ends the discussion.
Motion to strike all of council's comments and admonish the
They're
jury.
not evidence. We'll go ahead and take our morning recess, this time 15 minutes. Keep in mind, the admonitions previously given to you, not performed or express any opinions about the case, not to discuss the case, and we'll see everyone back.